should introduce Ryan. So I just wanted to say thank you so much to all of you for being here, and to Ryan, to Valerie, to Joe for hosting me here. It's an incredible honor to be able to speak to a room like this, and kind of a privilege to do so at a moment where we're all coming to grips with a really difficult reality, not just for our field, but for geopolitics, for relations between friends and neighbors. So where I want to start is there's a common perception out there that our current moment represents a total reversal in the American approach to international trade policy and foreign policy generally. There's a perception that this is a volte-face, a change, a 180-degree turn from what has been before. On this narrative, the US was, since 1945, the champion of free trade through law and legal institutions, a champion of multilateralism, a champion of international organization. But somehow, in January 2025, we plummeted into rank protectionism, imposing tariffs on everything with nary a mention of our international legal obligations, our commitments that we made. If you read the free traders' reactions in the Financial Times, the Washington Post, places like that, early in the Trump administration, second Trump administration's term, you get a sense that they, or we, free traders like myself, are suffering from whiplash. So on this narrative, the second Trump administration represents a 180, a rejection of the rules-based international legal order, which had been for a century as much an American project as anything else. Okay. At the same time, there are other voices out there. Other voices that blithely suggest that this is what we Americans have always been. A self-dealing hegemon, ruling through selective international law. And hey, at least now the mask is off. The sign is down from the window. What I want to get across more than anything else is that we have to resist both of these incidents. Why? Because both are true, and if both are true, neither can be quite right. So the reality is this. Post-war American foreign policy has been at all times animated by not one, but by two spirits. On the one hand, our policy has long been animated by a spirit of multilateralism, a true one, a committed idealistic belief in multilateral order. But at the same time, there's always been this spirit of unilateralism. The first spirit, multilateralism, is one associated with liberal internationalism, American engagement with, and in its conception, leadership of the world through global rules and global institutions, rules-based order. The second spirit of unilateralism is one associated with American particularism, nationalism, skepticism of foreign entanglements, prioritization of domestic concerns, domestic well-being over everything else. Post-war American foreign policy from 1994 to 2024 embodies a constant struggle for ascendancy between these two spirits, without ever either fully winning out. And this dynamic is linked to a common idea of American exceptionalism, a thing that is parroted in the United States constantly, that America is somehow special in the world, that America is a leader in the world, and America deserves, as such, somewhat special treatment. So the way that you hear this parroted throughout the 20th century is America is going to lead the world by remaking the world in its image, this is the American position, remaking the world in its image, based on values of free trade, free enterprise, individual liberty, but in recognition of American preeminence. Not all animals are created equal. We strove to erect a global legal system in our image and took our commitments genuinely seriously at the international stage, but could never truly imagine, could never really imagine that we would be completely and fully bound by the system that we were erecting. I don't need to tell you this today, that this is a story as old as the American century. But it's one which we kind of never really got to the last part of. My basic argument, then, is that America First represents something else. Something distinct, something radical, and something new, but not completely new. It's a bald-faced rejection of our legal commitments at the international stage, a bald-faced rejection of any independent authority capable of safeguarding the rule of law, a vision of US leadership in the world and engagement with the world for sure. It's not isolationism, but it's a leadership based on lawlessness, coercion, and domination. But the key thing to understand is this is not a shift from a century of plucky, happy lawfulness to an all-of-a-sudden change towards lawlessness, but rather a subtler shift from a kind of legal engagement coupled with a kind of intra-systemic lawlessness. We believe in the system, but sometimes have to push things in our way. A shift from that kind of a world to an extra-systemic or anti-systemic lawlessness that we see today. And though I am not really in favor of either, as you can probably imagine from the way this talk is going so far, the second is quite a bit worse. Intra-systemic lawlessness at least comes with a system, which has its own constraints, and with something to value, even if not an end in and of itself, even if not the ultimate goal. So my goal here is to trace the unilateral strain in American trade policy, focusing mostly on trade, in the era of American exceptionalism, from 1945 until 2024, in order to better understand our current moment of America first, and to see what needs to be done to dig ourselves out of it. I say ourselves, I mean us over here. You guys can help. Okay, so the high watermarks of American multilateralism, the multilateral spirit, come at two discrete historical junctures. When US leadership in the world was at its height, the end of World War II in 1945 till about 1947, and the end of the Cold War in 1991 through, for our purposes here, 1994. The monuments of multilateralism's success in the United States are our familiar international organizations, legal institutions, and multilateral treaty-based rules disciplining state conduct. So for our purposes, in a talk about trade, I'm referring to the General Agreement on Tariffs and Trade, the GATT, in 1947, and the WTO, erected in 1994. What I'm talking about today isn't really limited to trade. You can make similar points about the foundation of the United Nations, even about the International Criminal Court, but we're just going to focus the discussion on trade. I'm happy to go to general international law in the Q&A if you would like. The GATT in 1947, and even more so, the WTO in 1994, established firm and enforceable legal disciplines on the international plane on tariffs and other kinds of trade barriers. They were really serious commitments. And importantly, they were subject to compulsory binding third-party dispute resolution, a relative rarity in international law, where most disputes are resolved on the state-to-state plane. So these were incredible monuments to multilateralism's success, especially the WTO, bringing in the world after a schismatic era of the Cold War into one institution which will regulate international trade subject to pretty serious compulsory dispute resolution. That's remarkable, and there's no wonder it's called the crown jewel of international adjudication. But the spirit of unilateralism was never really vanquished, not even at these moments of multilateralism's greatest success. In fact, these treaties, the GATT and then the WTO in 1994, left certain doctrinal windows open towards the unilateral instinct. There are probably more than a few, but I'm going to focus on three of them for the purposes of this talk. The three are a window to unilateralism in what's known as trade remedies. So most disputes under the treaties are to be resolved under binding multilateral dispute resolution, but there are a couple of things where a state, if they think another country has been acting unfairly in particular ways, for example, product dumping, which I'll talk about in a moment, you don't have to go to dispute resolution. You can immediately and unilaterally act, and it only gets to dispute resolution if the other state thinks that you've somehow violated your right to act unilaterally and immediately. So there's this unilateral window to trade remedies. Another is in the procedures in which dispute resolution is going to proceed. There are all these tiny little rules which could be exploited to allow abuse, evasion, avoidance of binding dispute resolution. They were significantly worse in the GATT period, and they turn out to be still extant in the WTO period. And the last is a pretty familiar one. There's an exception in these treaties for national security. And it looks like a just giant gaping exception wide enough to drive a bus through. So at the moment of multilateralism's greatest success, all these little windows to unilateral action are left open, and it's obvious to all concerned at the time that these windows will be more accessible to the great and powerful, and not to a state which is relatively weaker. And I'm going to refer to powerful states a few times throughout this talk. I want to make crystal clear one thing. In international trade law, the measure of your power is not the gunboat, it's not bombs, it's not military. Power depends on the size of your consumer market. And the reason the Americans are so powerful is because we consume like nobody else. So you have these three windows to unilateralism left in the treaties. And over time, it takes a while the first time, it takes till about the 1980s with the GATT, but it happens much more quickly in the WTO. Over time, these windows kind of start to open on their own. Well, not on their own. In fact, the US tends to open these windows wider and wider, pry them wider, push the frames of the window to the breaking point. They do this through their practice, through advancing interpretations of their unilateral options under the treaties that are increasingly aggressive and self-justifying, to the point where one wonders how much these institutions can constrain at all. Why? Well, the reasons are varied, right? And I don't want to make any kind of causal claims about this. The reasons for unilateralism's gradual reemergence are a kind of complex of a bunch of different things. Sometimes it's a protectionist instinct. The whole point of these trade agreements is to remove the desire to protect domestic industries from foreign traders. At least it's one point of them. And everybody knows that there's an enormous temptation in democracies to respond to critical interest groups by protecting them in order to win their votes. And so the goal was to commit to this international system that would sort of take away those incentives. Okay. Sometimes, though, those incentives are too strong. And in the 1980s in particular, in the US, we had just signed away our right to impose tariffs on an enormous range of products in the Kennedy round in the 70s, and all of a sudden foreigners are in fact doing what we hoped that they would do, trading with the United States in enormous numbers, meaning that import penetration into the US economy skyrockets, meaning, unsurprisingly, a bunch of domestic industries are under threat. That's why you trade, because you can't do everything at home. Comparative advantage, the basis of all of this says, if you trade, eventually some businesses are going to get squeezed out. And you should probably deal with that through domestic policies, a safety net. Who knew? But what happens instead is these industries say to the US government, we're getting killed here by these foreigners, and do something about it. The US says, well, we can't impose tariffs because we just gave away our authority to do so, but we can use maybe some other tools, anti-dumping, other things. We'll get into it in a moment. So sometimes this is just about protectionism, prying open these formal mechanisms for unilateral action under the treaties to find other mechanisms than tariffs to protect domestic industries. Exactly the thing these treaties are meant to stop you from doing. But there are other concerns too. Sometimes there are genuine national security concerns. You don't imagine that the United States would agree to continue having to trade arms and munitions to Czechoslovakia in the height of the Cold War when it was under the Soviet umbrella. I mean, it's just unimaginable, right? So there are real security claims, there are ginned-up security claims, but they tend to get more and more over time. The key fact here that I want you to get is whatever the reasons, protection, geopolitics, security reasons, whatever they are, there's a complex of them. The fact is that protectionism tends to operate like a ratchet. The more you do, the harder it is to unwind and the more tempting it is to do more. If you protect the steel industry, suddenly the auto guys say, you're going to let us drown? And if you protect them, what about the farmers? What about ethanol? Right? Not every industry has political juice, but a lot of them do. And there's the unions to worry about. At a certain point, you're just protecting the whole economy and undermining the whole structure that you know to be in the interest of the American people, or of the people in any country that values free trade. So protectionism tends to beget more protectionism, and securitization, national security claims, tend to beget more national security claims. So all of this gets interrupted Right? There's a moment where the ratchet is broken because there's this gradual creep towards unilateralism over the GATT era, and it breaks in 1994 with the formation of the WTO. But that's at this critical historical juncture where the leadership class is able to muster incredible authority, having, in the American view, won the Cold War. Right? At this moment, we can reinvest in a new world, one without the schism of the East and the West, rule on free trade principles, and we need really some more authority to negotiate all of this stuff. That's the only interruption in the ratchet. And the ratcheting begins again in pretty short order after the WTO is formed. So you see the exceptionalist dynamic unfold in all three of these areas: in trade remedies, dispute resolution, and national security. Post-war America started deeply committed to erecting a multilateral system in its image. And we designed it to be strong. We designed it to be self-enforcing. But over time, for various reasons, the US begins to push open these windows to unilateralism, to exploit them, to advance exploitative interpretations, to justify its own unilateralism. I want to take a few minutes to get into the weeds of this, just so that you can see it, so it's not me telling you the same thing repeatedly, but to try to show it a little bit. Take trade remedies. Trade remedies, I acknowledge, is by far the most boring and banal of all of these things. It's the one which people dread to learn and people dread to teach. And yet, it's where all the action is. As lawyers, you come to realize the most boring, tiny little banal legal rules are often the things which everything turns on. So we sometimes have to take our medicine, including right now. So trade remedies. From the inception of the multilateral trade system, the idea was that most disputes would be resolved multilaterally. Yet there was a concern, especially pushed by the United States, that if we accede to this kind of a system where we all bind ourselves to the mast, someone's going to cheat. It's not that all foreigners are going to cheat us. That wasn't our attitude. That's the attitude now. But that wasn't the attitude then. The attitude then was, well, someone might cheat, and if we're tied to the mast, how can you resist that? What can we do? And what was the particular thing that we were worried about? We weren't worried about some of our domestic industries getting outcompeted. That's the point of free trade. You don't admit that as a politician, but that's the point. What you worry about is unfair action meant to dislodge domestic companies who should be competitive so that you can take over. Right? So the concern with product dumping is that producers from a foreign country will sell at below cost into our market to make consumers switch to them, put our domestic producers who should have been competitive out of business, and then jack up costs once they have a monopoly. It's a monopolization concern. I'm overstating it slightly, but that's the boogeyman when it comes to dumping. What you have to understand is that in a situation without that, dumping is a nasty word for exactly the kind of thing free trade is supposed to do. Get cheap products into our economy. So if you look at the GATT, if you look at the WTO treaties, there's a lot of language about dumping, but it's never said that dumping is illegal. Never says it anywhere. Why? Because dumping is a gift to domestic consumers. Yeah, continue selling us cheap stuff. I would like to buy cheaper avocados. I would like to buy cheaper bananas. I would also like it if my iPhone were cheaper. That's great, dump away. Who doesn't like dumping? Domestic competitors, domestic industry. And the whole point of free trade rules is to make things better for consumers, and sometimes domestic industry suffers the price. Not politically palatable, but that's the point. Okay, so we have this set of rules that they don't say dumping is illegal, but rather the trade treaties say, if dumping occurs, the importing state has the right to unilaterally investigate whether there's unfair dumping, and then unilaterally and immediately remedy that dumping by imposing costs on the specific company that they found to be engaging in dumping. What are those costs? They're effectively tariffs. It's like a tariff on that one company. Okay. So, dumping was treated as a specter that the US would need tools to excise immediately. But the treaties don't make dumping illegal, they just create an option to act on dumping. At first, the US approached this option in a really restrained way because they believed that what we really want here is to get cheap goods into everybody's hands and raise the standard of living for everybody. Doesn't mean cheap is bad, it's cheap is good. So from 1947 until the 1970s, domestic companies raised lots of dumping claims with US authorities. They complained about dumping constantly because it seemed like a good way to get the government to hammer foreigners, right? And the US government really didn't respond. They did investigate dumping. In fact, the number of dumping claims in the US hasn't really changed all that much over the years. And the thing is that from 1947 to the 1970s, the US basically investigated and found no dumping 99% of the time. And when they did find dumping, imposed very reasonable, moderate remedies. But beginning in the 1980s, the dynamic shifted dramatically. The US authorities began taking dumping claims all the way to the end, finding dumping in almost every single claim where it was made, and imposing really stiff remedies, remedies that were so stiff that they were almost inescapable. Right? That for technical reasons that are beyond even what I'm willing to say right now, the way that dumping investigations work is Kafkaesque. Once you're sucked into a dumping investigation, you can't ever really get out of it. There are a lot of reasons for this shift. I mentioned the post-Kennedy round, import penetration. Tariffs are low, it's impossible to legally raise tariffs now. Lots of imports are coming in, so the US just starts saying, well, that's dumping, when they want to exercise their protection concerns through some seemingly legal means. Another shift Doug Irwin identified that's kind of fascinating is that in the 1980s, the US government shifted authority for dumping claims from the Treasury Department to the Commerce Department. And the Treasury Department has a lot of important things to do. And so they weren't looking at these dumping claims and saying, we got to worry about monetary sovereignty, don't bother me with this is idiotic. Then they shifted it to the Commerce Department, who did not have as many important things to do with their time. And so said, this is great, we're going to find dumping. It's a little cheeky, but the point is institutional shifts can play a really big role, even if there's not some sort of grand intent behind them. So whatever the reason, whether it's protectionism, whether it just happens to be a shift in who has the authority to manage these claims or something else, anti-dumping claims become the weapon of choice for the United States protectionism from the 1980s on. And the US starts to interpret its right to do so in a really self-dealing way. Okay, the key thing is that we never looked back. The tendency is to ratchet up as soon as we start aggressively using anti-dumping, which is imposing tariffs on dumped products. We start to do it much more frequently. The total number of claims never really changes, but we start finding dumping in all of them and imposing massive tariffs in almost all of them. In 1994, at the time of the Reformation with the WTO, we agreed with other countries who were complaining about our anti-dumping practices that we need to do something to discipline all of this. Right? We need to agree. If we want to bring everybody else to the table and commit again to multilateralism, we need to restrain this. So the United States agreed to an entire treaty as part of the WTO package on anti-dumping, the anti-dumping treaty, creatively named. And that treaty basically subjects the US anti-dumping regime to something like the American Administrative Procedure Act. It doesn't make anti-dumping illegal, you're still allowed to do anti-dumping. But now you have to give reasons for what you do. You have to justify everything. You have to give timeframes to respond to companies you accuse of dumping. You have to do all sorts of really rigorous administrative law type of stuff, which is supposed to discipline abuse of the system. And it worked for a little bit, but within not that many years, the United States started aggressively interpreting every little rule in that anti-dumping agreement to squeeze out even more leverage to be able to engage in anti-dumping. It's one of those situations that anyone who's taken a contract law class will find familiar. The more complex you make your legal agreements, the more opportunity there is for mischief. And we were very good at finding mischief in the treaties. The difference now in the WTO era is that there was a system of very serious dispute resolution. And we were sued repeatedly over our anti-dumping practices in the WTO. And the WTO appellate body repeatedly ruled that we were violating the law. And we were not happy about that. A matter I'll turn to in just a moment. So the key is we never looked back. We agreed to disciplines on anti-dumping in 1994, but we just continued to ratchet our way towards more intra-systemic lawlessness by imposing ever more serious, ever more aggressive interpretations of the anti-dumping regime that we had just purportedly attempted to discipline. Okay, you can tell a similar story about dispute resolution from the beginning, and I'll do this a little more quickly. In the beginning, the GATT was not the first effort at creating an international trade order. The effort started as an effort to create something that looked quite a lot more like the WTO. It was called the International Trade Organization. It was the brainchild of a bunch of New Dealers, especially Secretary of State Cordell Hull. And the idea was if we created a body that was capable of regulating all aspects of trade, and everyone ties themselves to the mast, we'll all be a whole lot better off. Part of that requires binding third-party dispute resolution. And the idea in the original ITO draft in the late 40s, after the war, was that we would submit disputes under the International Trade Organization treaties, at first to a council, but eventually to the International Court of Justice, the ICJ. That turned out to be unacceptable to Congress, as did a lot of things in this ITO, and to other states as well. And so eventually, to cut the story short, we end up with the General Agreement on Tariffs and Trade, and dispute resolution was quite a bit weaker. It's a long story, but what effectively happened within several years, once it became clear that the GATT was all we were going to get in international trade governance, is that dispute would be resolved by third-party adjudication, supposedly binding, called panels. But the practice was that a panel could only be formed by a positive consensus of all states concerned, including the state being sued, that we agree to consensus, that when we reach consensus that a panel can be formed to hear the dispute, and if the panel issues a report, a ruling, then every state party to the GATT has to agree to adopt that report for it to become binding. So what does that mean? It means if you lose a case, then you have a chance to say, I don't agree, and then it goes away. Wouldn't that be nice? Right? I robbed somebody, I get sued, I get taken to court by the Attorney General or whatever, and I say, I don't agree to be bound by this, and I'm off the hook. Okay. So at first, lots of states abided by these panel rulings. They joined consensus to adopt them. There are lots of adopted panel reports in the GATT era because there was a spirit of multilateral compromise. But over time, states started resisting this. It wasn't that the US started first. Other states started doing it first, refusing to join consensus. And eventually the US started saying, well, if you guys aren't going to join consensus when you lose, neither are we. And by the 1980s, again in the 1980s, the US was basically pretty systematically refusing to join consensus every time it lost a dispute. They would allow the panels to be formed, they would lose a dispute, and they would just say, we disagree, we're not going to join consensus. Not every single time, but a lot. So the dramatic thing, and the thing most don't realize, is in the 90s, when it came to reforming the system, we were the ones who said this is an unsustainable system. We were the ones. The United States was the prime advocate for refiguring the international dispute resolution system in the WTO. We pushed for the creation of a much more mandatory binding system with a centralized appellate mechanism, an apex court for international trade, and a shift away from this positive consensus rule to what's called a negative consensus rule, making the panel reports, the appellate body reports, effectively binding. Negative consensus means the report will become automatically binding unless every single state, including the winning party, agrees that it should not be adopted. So we shift from a system where, in effect, dispute resolution isn't binding at all, to one in which it's, in effect, completely binding. And that was the US's idea. We pushed it in the Statement on Administrative Action submitted by the Clinton administration to Congress. They said repeatedly, they crowed about it. Look what we got everyone to agree to. We finally got binding multilateral dispute resolution. And they were serious. But it didn't take too long to start losing cases. And at first, if you look at what happens when the US loses cases saying your regulation was a violation of the rule against non-discrimination, the US kind of came out and said, well, you know, we have a different view, but we're glad that this system is working. We're glad that the WTO appellate body, even if they ruled against us, gave a reasoned award, and we're all for it, right? But then they start losing anti-dumping cases, and they're not all for that. And eventually, we start pushing back, finding ways to delay rulings, finding ways to drag things out to the bitter end, and ultimately, refusing to even participate in dispute resolution at all. And one could tell the same story about national security. It starts with a view that, well, national security is very serious, but we need to be restrained when we use it. If you invoke national security as a reason why you violated a trade rule, you're entitled to a ton of deference. But as scholars like Ken Vandeveld and Mona Pinchas-Paulson have shown, the US State Department's own view at the time of signing the GATT was that this would still be reviewable by the courts. It would still be reviewable by the panels in the GATT era. By the panels in the GATT era. But over time, again, it turns out in the 1980s, terrible era for international trade. In the 1980s, the United States started advancing a different view of the national security exception. That the national security exception was purely decisionistic. That when a state invoked it, that meant the dispute resolution system simply lacked jurisdiction to even hear a dispute. If you say national security, that's it. It wasn't always our view, but now we're saying that was always our view. And by the time of the WTO, we had made lots of national security claims. We kept that. Everyone agreed we needed to keep that language in the WTO system, and we then moved to more aggressively and aggressively invoking it. Enough about the details. Here's what I'm not saying. I'm not saying that American internationalism has always been cynical, that we were never really committed to this project. We were. If you look at the writings of Secretary of State Cordell Hull and his New Dealer cohort, they were truly committed to establishing real, functional global institutions. And the same can be said of the Clinton administration in the time of the WTO. Sure, we also said things like, there's no way this dispute resolution system will impact American sovereignty. There's no way they can ever make us change our rules. But the idea was, if we lose a case, we'll just pay. Right? That's still a valid remedy. That's still a valid way of handling the situation. It's not lawlessness. So you see the dynamic between multilateralism and unilateralism is always there, even if the multilateralism was serious. But that's what we have to remember. It was serious. So what I'm saying is that the multilateralism, the internationalism, was always serious, but our commitment was always tentative. Our idealism was always alloyed. In practice, over time, our better angels tended to struggle. So, as I've said, my goal here is to trace the unilateral strain in American trade policy through the era of American exceptionalism, which I date from 1945 to 2024. The goal is to better understand what's really distinctive about America first. So let's get back to our own times. My instinct is that our new outright lawlessness, our new unilateralism, has to be understood first in terms of continuities with what came before, in order to understand where the real ruptures are. My argument is that the critical difference with the law bending of American exceptionalism and America first is not a shift from bright-eyed lawfulness to a cynical lawlessness, but rather a shift from committed multilateralism alloyed with this kind of system bending to an extra or even anti-systemic lawlessness. The me-first spirit of unilateralism is not new in American foreign policy. What's new is its total ascendance. Or just to put it another way, all this represents a shift from an admittedly alloyed idealism to a posture of simple nihilism. So when and how does that shift happen? It's tempting to date things back to 2017, with Trump's initial election and turn to tariffs, taking office in 2017, and his turn to tariffs pretty early on in the administration. But you'll note I keep dating the shift at 2025. Why? It turns out tariff policy in Trump's first administration is not so different from what came before. Maybe there's a difference in degree, but not in kind. Because while imposing massive tariffs, and I think abusive tariffs, in Trump's first administration, there was an effort by the US trade authorities to always justify this in terms of WTO rules, in terms of the law. They were speaking legalese, even if they were bending the law at every turn. They were always justifying tariffs as trade remedies, anti-dumping remedies, national security measures, what have you. Now this is absolutely unilateralism, I'm not denying that. And in fact, most of these justifications were utter BS. Not all, but most. Utter BS. So this I take to be the poster child for a kind of intra-systemic lawlessness. It's bad. as a person committed to multilateralism and the rule of law, as an American committed to those things, I was ashamed of it. But there's still, as an international lawyer, you always have to keep in mind, it's better that states are speaking the language of the law than not doing so at all, because that constrains state action. That's often all we can hope for from international law. It's international law, not domestic law, right? The idea that the state felt constrained to explain what it was doing in legal terms creates a boundary to what is considered possible. And the same can be said for Biden's tariff policy, which we can't forget continued all of Trump's tariffs from the first administration, and in fact expanded on this trajectory for different reasons. Worker-centric trade, not America first, but still, why these workers, not other workers? It sounds like protectionism to me. The one exception in this first era, and I think it's the key one, maybe even the critical moment, is that along the way, the Trump administration destroyed multilateral dispute settlement completely. Root and branch. Now, it started as the same kind of intra-systemic lawlessness. The way that dispute resolution works in the WTO is that there's a panel, the first instance tribunal, and if they rule against you, you have a right of an appeal as a right to go to the appellate body. The appellate body hears your claim, and only after the appellate body rules does that ruling become de facto final. For the appellate body to hear claims, they need to have appellate body members, right? You need to have a quorum of members. That's a quorum rule, and they have term limits. The practice had been, from the beginning, that states would vote by consensus on whether to appoint particular people to the appellate body. There's a rule that says you can actually vote, right? So formally speaking, you could force a vote. But everybody kind of understood, we need to make sure all the powerful states are at the table, so we're going to do this by consensus. And actually, Obama first started refusing to join consensus on particular candidates to the appellate body who they thought were objectionable, but not systematically. They rejected a couple of candidates, allowed a few others forward. But what the Trump administration started doing right away, right off the bat, is that they announced they would systematically be refusing to join consensus to appoint any further members to the appellate body. They said basically that this was because the appellate body has engaged in overreach, lawmaking, yada, 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 but the reality was the person pushing this was Bob Lighthizer, the US Trade Representative, who had spent 25 years or more in private practice representing the steel industry, the greatest beneficiaries of US anti-dumping policy, and the most livid of all at the appellate body's striking down of the US's interpretations on anti-dumping. Not to just say it all comes down to one human individual, but in this case, it kind of did. Okay, so the United States refuses to join consensus on the appointment of further appellate body members. The appellate body loses its quorum, they can no longer hear disputes, and then what happens is the entire dispute resolution system falls apart, because if a court of first instance rules against you, a panel of first instance rules against you, you have an appeal of right. And if you don't like their ruling, you just say, I appeal. Well, there's no one who can hear your appeal. Well, too bad. I guess we're back to blocking judgments. I could walk away and not be found in breach. The whole thing falls apart. And Biden continued this, supposedly for other reasons, but they never really explained themselves, even when asked repeatedly and repeatedly and repeatedly. So, I still think one could look at all this as a kind of intra-systemic lawlessness, because the states, the United States, was acting within the rules. You were formally allowed to not join a consensus. The Europeans who wanted to insist on appointing members to the appellate body could have insisted on a vote, but they didn't want to because they were worried the United States would leave the WTO. So in a way, it was still this kind of intra-systemic thing we call in the US constitutional hardball sometimes. But the problem is that this left the institutions so hobbled that what came in 2025 took on a totally different tone, a totally different flavor. What came in 2025 has been different, an unrestrained fire hose of tariffs, with no effort at all to justify anything in international legal terms. The United States Supreme Court just ruled against Trump on all those tariffs, by the way. Most of them are going to come back. We can talk about that later. Still an important judgment. But if you look at all of the pleadings in all of the cases, you look at the amicus briefs in all of those cases, at every level, not a mention of international legal rules. It's all a question of domestic constitutional law. Everyone understands, nobody cares among the American authorities about what international law demands. Maybe this fight will be played out on the level of the Constitution, which still holds some salience domestically. But nobody's having this fight in terms of international law, to our great detriment. But critically, there's also no pushback at the level of international institutions. Not really. Why not? Because there are none left. In the earlier period, Trump and Biden had so hobbled the one international authority with the ability to declare decisively, authoritatively, that a violation of the law has taken place: the WTO dispute settlement body. And now, there's no reason to justify what you do in legal terms, because none's the wiser. No one can gainsay what you've done. If the European Union says the United States is breaking international trade law in committee in the WTO, the US can just say, no, we're not. And our view is as good as yours. There's no one to decide otherwise. And that's the key to understanding what's new. There's no one left to police the system. And so we, Americans, feel free to flagrantly ignore it. Hence, in my view, the critical shift was not necessarily a rejection of free trade multilateralism. That was gradual and maybe even cyclical. Rather, the key thing is our rejection of the rule of law, a rejection of the rule of law at the international level. And that happened all at once. So when we pick up the pieces, that's going to be where we need to start. On the level of institutions, my hope is that we will re-engage with the world. I think we will. But it will require a different kind of commitment to global institutions. One which we Americans have long resisted when push comes to shove. It's not just about recommitting to free trade. Free trade is valuable, but it's an instrumental good. It's about recommitting to the rule of law, to a world in which we are as bound as anybody else. And to taking what that means much more seriously in our practice, not only in our words. On the level of ideas, then, of course we need to come back from the brink of America first. I'm confident we will. But much more foundationally, when we start again, we need to look in the mirror much more deeply. When it comes time to start again, we need to abandon the nonsense of American exceptionalism as well. So to harken back to Carney, let's leave down the sign and hope to find a way forward on a more egalitarian footing. Thanks a lot.